It's Tuesday, June 10th, and it's 4:20 somewhere in the world. I'm your host, Radical Russ Belville. Produced and distributed by the National Organization for the Reform of Marijuana Laws in Washington, D.C., this is your NORML Daily Audio Stash, the growing truth about cannabis. Welcome to the most popular podcast regarding marijuana in all of America and all the world, featuring interviews with scientists, politicians, doctors, prohibition policy activists, regular cannabis consumers, musicians, artists, and NORML staff and NORML's board of directors, along with music and comedy no other podcast can offer. You can always find out more about the show at our website, stash.norml.org. and continue the education and conversation on our blog as well. We're ending marijuana prohibition with education, one listener at a time. The podcasting and blogging technology for the NORML Daily Audio Stash is provided by Red Aphid Interactive Media. Visit www.redaphid.com. All right, welcome to the Stash, everybody. Glad to have you here. Oh, boy, I am so behind on getting all of this video and audio processed from the weekend's Aspen Legal Seminar. So we're getting all the audio put together as well as the video that we're going to be putting up on YouTube. It'll be at our NORML YouTube channel, which you can find at youtube.com/NATL NORML. That's for National Normal. So youtube.com/NATL NORML. And I'll be posting those videos just as soon as I can get them cranked out here from the studio. Coming up in today's podcast, we've got some more audio from the Aspen Legal Seminar. We're going to feature Paul Wright, who is the editor and publisher of Prison Legal News, who's going to give us some information on prisoner litigation, including constitutional violations in prison. And we'll follow that up with Geraldine Merritt. She's the webmaster of TalkLeft.com, as well as a criminal defense attorney in Denver, Colorado, going to walk us through a look at the mandatory minimum sentencing schemes, especially with regards to crack cocaine and the disparity between crack and powder cocaine. And, of course, we're always taking your emails at stash@norml.org if you've got any news or information you want to share with the rest of the cannabis community. So enough of that. Let's get right to it. Grab yourself some gauge, sit back and relax, and enjoy your NORML Daily Audio Stash. Now it's time to take a look at the latest stories about marijuana from news organizations across America and around the world in our NORML Daily Audio Stash, Hemp Headlines. Former Georgia Representative Bob Barr. I was wrong about the war on drugs. It's a failure. From the HuffingtonPost.com, the words of former Congressman Bob Barr. I'll admit it, just 5 years ago I was public enemy number one in the eyes of the Libertarian Party. In my 2002 congressional race for Georgia's 7th District, the Libertarian Party ran scathing attack ads against my stand on medical marijuana. Today, I am their presidential nominee and will represent libertarians at the top of the ticket on November 4th. Huh? That's right. Bob Barr, formerly the war on drugs-loving, Wiccan-mocking, Clinton-impeaching Republican, is the presidential nominee for the Libertarian Party. For years, I served as a federal prosecutor and member of the House of Representatives, defending the federal pursuit of drug prohibition. Today, I can reflect on my efforts and see no progress in stopping the widespread use of drugs. I'll even argue that America's drug problem is larger today than it was when Richard Nixon first coined the phrase war on drugs in 1972. America's drug problem is only compounded by the vast amounts of money directed at this ongoing battle. In 2005, more than $12 billion was spent on federal drug enforcement efforts, while another $30 billion was spent to incarcerate nonviolent drug offenders. The result of spending all those taxpayers' dollars? We now have a huge incarceration tab for nonviolent drug offenders and, at most, a 30% interception rate of hard drugs. We are also now plagued with the meth labs that are popping up like poisonous mushrooms around the country. While it is clear the war on drugs has been a failure, it is not enough to simply acknowledge that reality. We need to look for solutions that deal with the drug problem without costly and intrusive government agencies, and instead allow for private industry and organizations to put forward solutions that address the real problems. Now, if we can only get Bob Barr and Ralph Nader on the stage alongside Barack Obama and John McCain in a televised debate. Imagine the candidate of the left and the candidate of the right being pummeled on the drug war from candidates that are even farther left and farther right. Okay, I'm a dreamer. Obama and McCain will probably be the only two we really hear from, knowing the way that they structure these debates. But I wouldn't count out Barr just yet. John McCain was only getting 70% or so of the vote when he was running in the primaries, even as the de facto nominee. So there's a lot of Republicans who will vote Libertarian this year, Tom DeLay's wife being one of them. And who knows how many disaffected Hillary Clinton supporters will turn to Ralph Nader. Well, whatever gets people talking about the war on drugs being the problem more so than the actual drugs, I'm all for it. New York court. Small amounts of marijuana in prison, not a felony. Albany, New York. From the Associated Press. New York's top court says small amounts of marijuana in prison do not represent dangerous contraband under the law and ordered lower courts to reduce 2 convictions to misdemeanors with shorter sentences. According to the Court of Appeals, Kyle Salter's case involved 9.3 grams of marijuana that his girlfriend tried to bring him at Bear Hill Correctional Facility in 2003. Robert Finley had 3 joints in 2004 at Orleans Correctional Facility. Both were convicted of felonies, with Salters sentenced to 2 to 4 years and Finley to 3 to 5 years. The court majority says the test for dangerous contraband is its likelihood to be used in a way that causes death, injury, escape, or other major threats to prison safety or security. Well, that's good news for any drug war POWs whose sentences may be reduced. But every time I report on a story of drugs in prison, it always underscores how futilely stupid the war on certain American citizens using non-pharmaceutical, non-alcoholic, tobacco-free drugs is at its root. We can't keep drugs out of our federal prisons. A place with walls and fences and dogs and guards with guns and cameras inspecting every square inch. How do you expect to keep drugs out of our country? We can't stop prisoners from doing drugs. People whose every movement is managed, every bedtime scheduled, every activity monitored 24 hours a day. How do you expect to stop a free citizen from doing drugs? By putting him in prison, right? And furthermore, if small amounts of marijuana aren't dangerous contraband in prison, then how could they possibly be dangerous contraband out on the streets of America? Ex-felon grateful for medical marijuana in Montana. From HelenaIR.com. A week after the state corrections department abandoned a proposed rule that would have banned anyone on probation or parole from using medical marijuana, one Missoula man says he's already reaping the benefits. David Michaud, 39, a convicted felon and stay-at-home dad who uses medical marijuana to relieve chronic migraine headaches, pain, and nausea, said, quote, "I was told that I could go ahead and toke up again," end quote. In 2000, Michaud was arrested with 4 ounces of marijuana during a ski trip to Breckenridge, Colorado, and was subsequently convicted of felony drug possession. Earlier this year, Michaud and his wife moved to Montana, where he is registered as a medical marijuana patient and has 4 prescriptions for the drug signed by 3 physicians. But Michaud said his probation officer told him he couldn't fill those prescriptions and suggested he instead ask his doctor for a prescription to Marinol, a synthetic version of the active ingredient in marijuana. But Michaud says, and many patients agree, that the synthetic treatment is not as effective because it mimics just one substance in the cannabis plant, when a combination of substances may be what helps relieve the pain. Michaud said he disclosed his marijuana use to his probation officer after studying the finer points of Montana's medical marijuana law, which places no restrictions on probationers or parolees. Michaud said, quote, "So I told my probation officer that I had started following my doctor's advice again and was smoking marijuana, and she sent me to jail for 3 days." End quote. Diana Koch, chief legal counsel for the Department of Corrections, said her hands are tied because of the way the initiative passed law was written. Quote, "The medical marijuana statute just doesn't allow criminal consequences for someone who is legitimately authorized to take medical marijuana. We hope this isn't going to give a carte blanche license to every drug offender who wishes to obtain marijuana," Koch said. "It is so difficult to rehabilitate people with drug addictions when they are told it is okay to have drugs. We just hope public safety does not get out of hand and the public is not as safe if drug-addicted people are allowed legitimately to have a drug." End quote. Michaud said his life is easier now that he doesn't have to defy his probation officer and that the pain management is critical to his quality of life. He said, quote, "It's awful not being free of pain. I mean, they could prescribe me narcotics or painkillers, which are more toxic and more expensive than cannabis. It's a shame there's such a stigma on marijuana." End quote. Well, you have to wonder what Diana Koch thinks about probationers and parolees who are out walking the streets right now with prescriptions for Vicodin, OxyContin, or Xanax. I sure hope public safety does not get out of hand. And why is it that public safety is threatened by the THC in marijuana, but not the THC in Marinol? Ms. Koch, having ex-felons on marijuana may actually be one of the best outcomes you could hope for. Staying at home, being mellow, watching cartoons, eating cookie dough. Hey, you know where they'll be, and there'll be no harm to anyone.
Hello, I'm Paul Stanford from the Hemp and Cannabis Foundation, or THCF. Medical marijuana is legal in 12 states today, and THCF has medical clinics in 6 of those states. Our physicians help qualified patients obtain an authorization for medical marijuana in their state. Patients are eligible for medical marijuana with a history of either severe chronic pain and or nausea, cancer, AIDS or HIV, hepatitis, glaucoma, seizure disorders like epilepsy, chronic muscle spasms as in multiple sclerosis or asthma, neurodegenerative diseases such as Alzheimer's, and gastrointestinal disorders like IBS or Crohn's disease. If you or someone you know has one of these conditions, our doctors will help them obtain a permit for medical marijuana. THCF Medical Clinics has offices in Washington State, Oregon, Colorado, Nevada, Hawaii, and California. Call 1-800-723-0188 or go to the web at www.hemp.org or 1-800-723-0188.
Hey Stashers, more audio from our NORML legal seminar just held in Aspen, Colorado this last weekend. I'm bringing to you now Paul Wright, editor and publisher of Prison Legal News and an expert in the law when it comes to incarcerated citizens. So this is a talk that he gave on prisoner litigation, including the constitutional violations that happen in prison and just what the rights of prisoners are. So enjoy this little clip, and if you'd like the full version of this presentation, check out our special events feed on the right sidebar of the Stash blog at stash.normal.org. This is Paul Wright.
The counter response wasn't long in coming. Pretty much it came down to the point by the early 90s. It was one of those things that if the federal courts are going to respect the rights of prisoners, even nominal and minimal as they were, if they're going to put population limits on prisons, if they were going to restrict some of the terms and conditions, going to require medical care to be provided, if they're going to require the prisoners to be protected from harm, from being beaten by staff or raped by other prisoners or staff, then we have to do something. And this wasn't long in coming. In 1996, Congress enacted and Bill Clinton signed what I call kind of the trifecta of anti-prisoner rights legislation. I assume most of you are familiar with the Anti-Death Penalty and Effective ADEPA, the Anti-Terrorism and Effective Death Penalty Act. It's pretty much gutted habeas corpus in the criminal realm, which that wasn't, that was a real disaster for habeas defendants. The Prison Litigation Reform Act was the civil rights version of ADEPA. And what the PLRA did is it made it a lot harder for prisoner litigants to get into court. It imposed administrative exhaustion requirements, which meant that prisoners couldn't file lawsuits in federal courts unless they first exhaust the grievance system. And this has led to some pretty bizarre results in a lot of states where prisoners may have 2 days in which to file a grievance after an incident happens. And basically, if you blow that 2-day deadline, they can't file a lawsuit in federal court. In some of these other cases, for example, medical neglect cases, one of the things that comes up a lot is it's hard to pin down when the date of accrual was. In other words, when did your date to file the grievance start? And it kind of gets a lot of the statute of limitations because states are now using these very short grievance periods as far as when to start the timelines for grievances. One of the biggest things that did, in my opinion, the most devastating effect that the PLRA did is to cap attorney's fees. Someone once said that the most unpopular person in America is a poor person with a lawyer. And I think if you put down, I think that's an understatement. The really most unpopular person in America is a prisoner with a lawyer. And so one of the things that they tried to do, there's never been a huge number of lawyers willing to take on prisoner cases. And so one of the things, but that said, there's also the possibility that for lawyers that represented prisoners and who were able to win and secure relief for their clients, they could get paid market wages under Section 1988 of 42 U.S.C. So what Congress did with the PLRA is they put various caps on the attorney's fees that were available for prevailing counsel, and this included capping the market wage or the market rate to whatever the CJA panel rates were, which at this point to 150% of the CJA rate, which at this point is around $169 an hour, which there may be some place in the Midwest or some smaller communities that might be a pretty good sum, but since you start getting the coasts and that, it's hard to run a law office on $169 an hour. Those were some of the, and this has also led to very ridiculous results, which have also been upheld by the circuit courts, one of which is that they also cap, in some cases, the attorney fees are also capped at a percentage of the recovery, 150% of the recovery of the damages in the case. So we have cases where prisoners have been beaten, they go to a jury trial, jury finds yes, your rights were violated, but we're only awarding you $1 in damages, and kind of the final insult to injury is the court then awards $1.50 in attorney's fees, which, needless to say, this has the desired effect. It's hard to find lawyers willing to take these cases. And the other wing of this, or the final leg of the of Congress and Clinton's hostility towards prisoners, was they imposed restrictions on the legal service corporations so that anyone who accepts LSC funds can't represent prisoners. And this is kind of the thing of the right-wing Congress too. It's not just prisoners, but anyone wanting, any women wanting abortions can't be represented. Immigrants seeking a challenge, deportation or citizenship also can't be represented. So the LSC restrictions are kind of a little wish list of the right wing here, and prisoners are on it. So this is basically, these three laws have had a real devastating effect on the ability of prisoners to obtain counsel and also to obtain redress or even get into the courthouse door in many cases. I guess as far as a real quick summary on the constitutional rights of prisoners, this is the real nutshell version. As far as what's available, what rights are being litigated, and what's going on. When I say nutshell, this is, I was just at a conference in Washington, D.C., and usually I give presentations just on narrow things like First Amendment rights, and that's usually a 2-hour seminar. So you can really you can really delve into a lot of detail on these issues. Prisoners retain rights to free speech. That includes the right to receive books and materials. Prison legal news, we're not very popular with prison officials because we tell prisoners what their rights are and how to assert them. And so the result has been that we've been censored a lot. And we've also been very successful at doing litigation. One of the things that happens is that to avoid the Prison Litigation Reform Act, we've been able to find counsel who represent us as the plaintiff so the PLR rate doesn't apply. So our attorneys are able to get market rate fees. And at this point, the entire state prison systems of California, Oregon, Washington, Nevada, Kansas, Michigan, and Alabama operate under PLN consent decrees, injunctions, or both. Some of them are recidivist censors, so we have to sue them a couple of times before they get with the program. So that's one of the things. As far as prisoners retain the right to free speech, they retain the right to receive and send mail. Technically, they have a right to visits, but the U.S. Supreme Court has made that pretty much, the case law on visiting is pretty bad, which is basically, the nutshell version on that is prisoners can receive visits kind of by the grace of the prison officials, and that's about it. Prisoners have First Amendment rights to freedom of religion, and that also includes the freedom not to be proselytized too. And that's kind of the flip side of the same coin there. The Fourth Amendment, which I assume, given your guys' field, is, as Jerry was going on about how bad things are on the outside, well, on the inside it's even worse. Basically, the U.S. Supreme Court has held in a series of cases, one called Hudson versus Palmer, is that basically prisoners have no Fourth Amendment right to privacy while in prison. Prisoners have a limited Fourth Amendment right to privacy when it comes to body cavity searches, and even that's a little shaky. The Eighth Amendment has several different components. This is the part of the Constitution that says that cruel and unusual punishment won't be imposed. And this, the different components on this is that prison staff can't use excessive force against prisoners. Prisoners have a right to be protected and kept safe from other prisoners. That includes assault, sexual assault, and whatnot. And it's also, and interestingly enough, prisoners are the only Americans in this country that have a constitutional right to medical care. And that includes mental health care as well as adequate medical care. And like everything else, it's one of those things that's being hard put as far as enforcing it. Prisoners also retain the right to due process. Before prison officials can take good time that would lengthen prisoner sentence, they have to be given a hearing that has very minimal requirements for due process. This includes the right to call witnesses, to see the evidence against them, to have written decisions, written fact-finding decisions by the decision maker, which typically these hearings are conducted by prison employees, which then there's been court cases on this, which is, well, they can't be, the hearing officer can't be related to the officer that wrote up the infraction, and stuff like that. So, but very minimal, very much due process light.
Just say no.
No matter what you call it, it's a huge part of popular culture.
Where'd you learn that, Cheech? Drug school.
You don't need weed school. You just need a copy of the new book, Pot Culture, the A to Z Guide to Stoner Language and Life.
Hey, this is great, man.
Even if you never smoked marijuana.
I never used marijuana. Sorry.
Don't think you smoked marijuana.
I experimented with marijuana a time or two and didn't inhale.
Or you used to smoke marijuana.
I inhaled frequently. That was the point.
Pot Culture by former High Times editor Steve Bloom and Shirley Halperin will answer every question you've ever had about marijuana culture.
Has that marijuana made it back up here yet?
Check out Pot Culture, the A to Z Guide to Stoner Language and Life at Amazon.com or visit potculturebook.com today.
Too bad, man. I just stopped smoking yesterday.
Here at the NORML Daily Audio Stash, we work hard to change our nation's marijuana laws through education and discussion. But we also take the time to relax and unwind with an eclectic mix of pod-safe music from many independent artists. We look for music that speaks to the growing truth about cannabis, or music that speaks to broader themes of freedom, liberty, social justice, equality, and protest. To find out more about the artists and download the music you hear on this podcast, just log on to stash.normal.org. And if you'd like to get your music heard by the online cannabis community, just send us an email at stash@normal.org. bit of underground hip-hop to brighten your Tuesday, Stashers. Mole Men is a trio of hip-hop producers from Chicago, Illinois, who have collaborated with Chicago rappers as well as rappers on both coasts. The trio consists of Mimo and PNS, along with Panic, who brings us today's track, Puff Another Blunt. This haunting hip-hop beat comes from Volume 13 of the Mole Men Instrumentals, a series of instrumentals with cutting-edge music and soul-searching idioms. This is just one of the 35 tracks on this album, all suitable for a trip-hop afternoon of smoke and contemplation. You can learn more about Panic and Mole Men by visiting our website at stash.normal.org. We've got links where you can pick up their album and learn more about the band. Also, you'll be able to download an MP3 of this song. It's Panic and Mole Men with Puff Another Blunt. It's tough talking to kids about marijuana, especially if you might be a parent who dabbled a time or two in your youth. So to help you out, get your copy of Dr. Mitch Earlywine's latest book, A Parent's Guide to Marijuana. Dr. Earlywine is an associate professor of psychology at the State University of New York at Albany and an expert on the studies concerning marijuana, its effect on health and society, and the methodology behind the statistics. He is a frequent guest here on our daily audio stash. Dr. Earlywine lays it all out without the propaganda and scare tactics that parents know won't work with teenagers. He presents a rational understanding of cannabis, what it is and what it isn't, and why kids shouldn't be using marijuana. You can order today through Amazon.com or check our links at our blog, stash.normal.org. Geraldine Merritt is a well-respected blogger, blogging for TalkLeft.com on the political side, but also she's a criminal defense attorney in Denver, Colorado, who's argued in appellate court level many cases having to do with crack cocaine, specifically the sentencing disparity between crack cocaine and powder cocaine and how that's controlled by our mandatory minimums. This little bit of presentation from Geraldine talks about those mandatory minimum sentences and some of the efforts underway to repeal those mandatory minimums. Again, if you'd like to hear the full presentation, check out our special events feed on the right sidebar of the blog at stash.normal.org. This is Geraldine Merritt.
All right, so let's start with the mandatory minimums. The mandatory minimums came in 1986. The next year, what they did was they provided that based on a quantity of drugs, there were some drug offenses that were going to carry a mandatory minimum 5-year penalty, meaning you literally had the floor, the bottom sentence you could get was 5 years in prison. For other offenses, with a greater quantity, the mandatory minimum was 10 years. On the other hand, there's other mandatory minimums that they use as leverage, the 20-year mandatory minimum, which has to do with if you have a prior state or federal drug conviction, they can then file a notice under Section 851, which basically says that you're looking now at a 20-year mandatory minimum instead of a 10-year mandatory minimum. So that's why I say, the mandatory minimums trump the guidelines, so no matter what kind of relief you get under the sentencing guidelines, they are never going to be able to go under the mandatory minimums. The only way you get under a mandatory minimum is either with a limited relief, with what's called a safety valve, which applies to a select number of people who don't have guns or violence in their crimes, and then the court can depart, but again, only a limited amount, or if you cooperate. It's the prosecutor who can ask the judge to go below a mandatory minimum. The court cannot do it on its own motion. And the only reason for that the prosecutor can ask for it is if you provide substantial assistance in the investigation or prosecution of another person. So if you're willing to become a cooperator, then you can get under a mandatory minimum. If you're not, you're stuck with it. They came in basically under Ronald Reagan when he did the 1988, I think it was, Drug Abuse Act. And this is where, if you remember, he called it a new sword in his shield, and he credited his wife Nancy. And what he said to America was, speaking to Nancy, Nancy, for your tireless efforts on behalf of all of us and the love you've shown the children in your Just Say No program, I thank you and personally dedicate this bill to you. So that was Nancy's present, and we all got the benefit, which was the Anti-Drug Abuse Act. And what Nancy had to say about it was, not long ago in Oakland, California, I was asked by a group of children what to do if they were offered drugs, and I answered, just say no. Soon after that, children in Oakland formed a Just Say No club, and now there are over 10,000 such clubs in the country. So that's how we got Just Say No. Now, here's the problem with the crack versus the powder and what everybody talks when they're talking about the disparity. It takes 5 grams of crack cocaine to get a 5-year mandatory minimum sentence. If you think about what 5 grams is, most of you, even from defending these cases, would know that an 8-ball is like 3.5 grams. Okay, so for 5 grams, you get 5 years mandatory minimum. On the other hand, for powder, it takes 500 grams. Okay, so it takes about a pound of powdered cocaine to get a 5-year mandatory minimum sentence. It only takes 5 grams of crack. So the ratio is 100 to 1, whereby crack is penalized at 100 times the amount the powdered cocaine is. When you go up in the scale, if you have 50 grams of crack, which is less than 2 ounces, you're looking at a 10-year mandatory minimum. In order for powder cocaine to get a 10-year mandatory minimum sentence, it has to be 5 kilos. So that is a huge difference between 5 kilos and 50 grams. And so that's, again, the 100 to 1 disparity. And what they've found is there's no rational basis for it, there's no scientific basis for it, and it's applied in a racially disparate manner. After all of the studies that have been done, science has generally agreed the 2 substances are pharmacologically identical. There is no difference between them. It used to, back in the Ron and Nancy Reagan days, it was that, crack was kind of like, it was this absolute total devil. It was more addictive. It made people go out and shoot people. It made people go out and commit crimes, and we had to do something to stop it. That is now also debunked. And what we're left with is the fact that it's applied in a racially disparate manner because the vast majority of crack users are African American, whereas the vast majority of powder offenders tend to be white or Latino. And so you have prisons that have filled with African American, usually young males, but women also, doing these double-digit sentences for relatively small amounts of crack. The problem is compounded by the fact that the government charges cases as conspiracies. You know, the federal government rarely is going to take one person and charge him with distributing 10 grams of crack. You know, it's just not really how it does it. So what it does is it busts a whole group of people, and then under the sentencing guidelines, they are liable for all of the conduct of all of the conspirators that's reasonably foreseeable to them, which generally means from the time that they joined the conspiracy till the end of the conspiracy, anything that anybody distributed during that time is attributed to them, even if they didn't know the person, even if they didn't know that that person was involved with the person they were dealing with. And then one of the exceptions to that might be a buyer-seller relationship if you can convince the court that it was just you and your seller or you and your purchaser and you weren't part of any overall conspiracy. But if there's any kind of interdependence at all, for example, if the drugs are fronted to you, the court will say, no, you're not a buyer-seller. And if you had any awareness that this person was selling to other people, then you're also going to end up being part of this conspiracy. So what happens is, because the sentencing is done after, you know, at a separate hearing, the burden of proof is less. It's not beyond a reasonable doubt at sentencing. It's by basically a preponderance of the evidence, and the judges can consider hearsay. You can literally go through a trial, get convicted of and I actually did an appeal for a guy who's now doing life, and what he was charged with was 251 grams, which would have gotten him a 10-year sentence. But when it came to sentencing, one of the cooperators got up at the sentencing hearing and said, well, I bought a kilo a month from him for 4 months. And even though this didn't come out of this trial, and the judge added 4 kilograms onto his 251 grams. And then because the kid he was like 27, he had had a traffic stop in Utah the year before where all of the evidence was suppressed, and so the charges against him were dropped. But there happened to be a gun in the glove compartment in that car stop, and even though he was the passenger and didn't have the key, the judge added an upward adjustment for the gun onto his sentence, even though that case had been suppressed, because they're not bound by those same rules of evidence, and this judge could consider that even though it had been suppressed. So by the time the judge was finished with this poor kid, who was his first felony, he ended up getting life in prison. And I remember I didn't do the trial but the appeal, and I remember telling the 10th Circuit, and, you know, doing my oral argument, and the last thing that they wrote in their opinion in affirming his appeal was, it is a tragedy that a 27-year-old must spend the rest of his life in prison, but that is what Congress has decided, and we are powerless to change it. And that just goes to show you, again, the need for the mandatory minimums to be changed, and the need for the disparity between the powder and the crack to be changed, because otherwise our prisons are going to continue to fill up. Some of the people who are on our side in this are the prison guards, which, you know, is kind of unusual. But the prison guards union has, you know, offered to testify in front of Congress and do everything else, anything it can to get these sentences reduced, because they think it's dangerous for them. When you have a young kid looking at 30 years or life, he's got nothing to look forward to. He's not getting out, and that creates more of a there's no incentive for them to either be, you know, on good behavior or anything else. They basically feel like their life is over, and it is. And they act that out in prison, and so the guards want the sentences reduced so that these kids can have some kind of carrot so they can, you know, have an incentive to do well.
Thank you for downloading the NORML Daily Audio Stash, the growing truth about cannabis. We are produced by the National Organization for the Reform of Marijuana Laws in Washington, D.C. Our executive producer is Alan St. Pierre. Our deputy director is Paul Armentano. Our webmaster is Brian Judy. And web production is provided by Red Aphid Interactive Media. As always, you can catch up on the latest information about marijuana at www.norml.org. And you can interact and download from our Audio Stash blog at stash.norml.org. For everyone here at NORML, I'm your host, Radical Russ Belville, hoping all your harvests are bountiful and your encounters with law enforcement are non-existent. We leave you today with another cannabis quote, this one from Ronald Reagan, the former president, who said, quote, "Government exists to protect us from each other. Where government has gone beyond its limits is in deciding to protect us from ourselves." End quote. Unfortunately, the Gipper didn't take that to heart when it came to marijuana. He felt it was just fine for government to try to protect us from ourselves and try to get us to just say no. Oh well, it's not like we haven't seen hypocrisy in politicians before. I'm Radical Russ. Thanks for joining us here for the Daily Audio Stash. We got more highlights from the Aspen Legal Seminar coming up for the rest of the week. And until next time, take care of each other, tokers.